Good evening. Welcome to Defacto Review, our weekly in-depth analysis on the current news and affairs with our commentator and lawyer, Ms. Namangil.
Good evening.
Good evening. And I'm your host, Namsred Sindh. You can join in on our conversation on MNB World Facebook page and on Twitter with hashtag Jargal_Defacto. Now let's get into our topics for today. The Constitutional Court of Mongolia made a decision to abolish mineral resources tax. There was an incident of spying on journalists in April of 2018 which involved Minister of Justice. Sandui and Ganbaatar was given a sentence for different offense because the case was transferred from the prosecutor to the court. Now let's get into our first topic. Two incidents related to the Constitutional Court of Mongolia has happened this week, one of them being a decision to abolish certain articles of minerals law on the 30th of October, and the chairman of the Constitutional Court, Otbayer, was detained in Incheon, Korea. So about this one, our first question is, does the Constitutional Court of Mongolia has the right to make a decision about economic policy? And is the decision about abolishing the certain articles from minerals law is right?
Okay, according to the Mongolian constitution, the constitutional state has a power to review the constitutionality of all the laws and also acts of certain high officials. So which means that technically it has a power to review constitutionality from the perspective of constitutionality, not from the policy or political perspective. This decision do in fact invalidated the royalties generally for the minerals. And as some people mentioned in the social media that it's invalidated specific amendments of this year's March, which means some people claim that which means that the previous version of the law would be restored, but there is no this kind of automatic restoration of the previous version of the law, which means that basically currently we don't have valid legal basis for the royalty for all the minerals.
So
yes, and we, in order to evaluate if it's a policy issue or constitutional issue, so we also have to see the description or interpretation of the certain constitutional amendments that are mentioned in the Constitutional Court decision. Of course, this decision do in fact have effect on the economy, of course, and it's mentioned two articles from the Constitution which was breached through these royalty clauses. First one was very general a clause which mentioned that the state would regulate the economy with the view of development of social development, also development of the old modes of production. The second clause the Constitution mentioned is that, which is also very general, state duty principle, we call it, which means that the state have to create all the social conditions for the human rights, for the ensuring the human rights, which is also very general. And in order to evaluate that if it's really breached this clause, we have to go through the decisions, interpretation of these clauses. But when I see the decision is already been published in Legal Info, it's not really convincing, I would say.
Right.
For example, in the interpretation, which mentioned in the, it's also, many of you know that a constitutional decision has a previous stages of making judgments. The judgment was published in June this year. I see this judgment and the decision of the previous month as well. And in the judgment it mentions that it's basically very rare that the Constitutional Court would mentioning the policy documents in order to describe the constitutional clauses. It's usually the theories and the parliamentary acts they would cite, but this time they would, for example, in this case, they cited state mineral policy or something, which also said very general things like Mongolia will support the modes of production, or Mongolia would support the industrialization of this kind of very general stuff.
So,
yeah.
Is this really right? What do you think? How would it affect the economy of Mongolia?
Yeah. As a lawyer, I'm not going to talk about the economic consideration. I'm just trying to say that in principle, usually whether to tax the certain sector or whether to double tax the certain sector, it's an economic issue. Right. So I think it, especially on the political and economic issue, Constitutional Court, especially when the issue is really this highly sensitive, Constitutional Courts and around the world as well, the judicial review also have this kind of principle of self-restrainment. So I think this principle should apply this kind of issues now in Mongolia as well.
So about this new amendments, the Chief of Staff to the President of Mongolia, Mr. Iqbal, and Minister of Finance, Mr. Hurlpat, are against this decision. So who is right on this one? Why would they be against it?
As I understood, if I understood rightly, the Minister of Finance said it will really affect our next year's budget, which will decrease because now we have a very short time to pass our budget, and if we don't decide this stuff before the passing the budget will have a lot of problem afterwards, right? So I'm not sure about as I understood, also Minister of Finance also sent the new amendments to the draft amendment to the bill to the Parliament as well. So I hope that they will manage it before the budget deadline as well. Yeah. Right.
So let's get into the second part of the topic. The chairman of the Constitutional Court, Mr. Otbay, was detained in Incheon. What happened? And as a chairman of the Constitutional Court of Mongolia was involved in this, what kind of punishments will he receive?
Okay, so as a citizen, I also have the same amount of information as everyone, I guess, from the social media. So, and we're just talking about this case, this issue, especially related to this specific officials within the information we just gathered. So. Sexual harassment, especially in the workplace, is of course highly inappropriate for this kind of high official, and also for of course all the officials within the state office and also the private market as well. And then if this would happen, this really happened, we're just talking in the if condition, right? I've seen these legal regulations related to this incident, and it seems that then we have this public service law, and public service law includes the specific prohibitions of for these civil services servants like officials, and this prohibition clause includes the sexual harassment. So if someone would do this kind of stuff, the law also provides the disciplinary acts, including the removal from the office as well. Right. But the thing that is not clear is who's going to enforce this law against this high official.
Ranking official, right.
Yes, because usually disciplinary acts would be enforced by usually the highest level of the organization, chair of the organization, and it's also constitutional states also does not have own ethical conducts or ethical rules. So. Separate rules, because usually the state offices would have separate specific code of conducts which regulates this process.
Right.
So in this case, I'm not sure how it will go into going forward in terms of legal norms. But if it really happens, I expect, and I think many of us would expect, that this kind of high official would resign himself without, waiting for or without having pressure from the society that it should be, decided.
Well, as you said, like if something else would happen, who would oversee them? They are pretty high-ranking officials, and if they're involved in any other maybe criminal offense,
a criminal offense it's decided. The criminal offense is decided because there is a specific laws, and also laws. There is and also the constitutional CITS law also provides very clear regulations that if the members of the CITS had some incidents with the criminal act, it's actually, the law is there. But this one is not a crime. Sexual harassment is not a crime according to the Mongolian law. So that means that it becomes more of an ethical issue. And also we have this petty offense law, small offense law, many translations are there. There is also, sexual harassment is also not there. Right. So it basically becomes a disciplinary act. Yeah.
I see.
Yeah.
So let's get into our next topic.
Okay.
Spying and tapping the conversation of journalists is not a new one. Previously, around 8 journalists were spied on in 2018, and this problem was raised again this week during the Journalistic Ethics Forum. So our first question about this one is that Minister of Justice was involved in this previous problem with spying on journalists in April of 2018. Could you give us some background information on what exactly happened?
Okay, as far as I remember, the issue came to the public knowledge in April 2018, right?
Right.
And by the State Intelligence Office, that they are investigating two officers from the police for illegally investigating, illegally spying on the journalists without proper authorization from the prosecutors. Because in order to do this secret investigation, there should be specific procedures should be followed, like having authorization from the prosecutors and having authorization from the higher officials as well. So the issue is, as I understood, the issue was raised recently by the member of the parliament, which is also which signifies, I think, some issue there in the press forum. And after that, the General Police Office also provided some statement regarding to this issue, right?
Right. So what is the current state of this case? Is it really already solved or still being investigated?
Yeah, from the statement of General Police Office, as I understood, case of two intelligence officers was investigated. It was investigated 2 years ago, but now it's closed because it's unfounded, I guess, legally and factually as well. And the officer from General Office also went on to say that currently there is no criminal case involving journalists at the docket. So, and as I understood, the case is closed. So there is no case, but the police officers also say that if there is a complaint regarding this kind of secret investigation in relation to journalists' work, one can complain, right? But I don't think this is a valid point, because how we would know that we've been wiretapped or investigated secretly, right? Yeah.
So how did the case went? Because since the police themselves are involved in it, would they be willing to give out all the facts and other information about related to this case, how it actually went? And what happened to the journalists who were being spied on?
I think that as far as the current media says, it's not really, in terms of official record, it was closed. These two officers went on to work in their office again, so they're not really removed from the office, which means that officially they did nothing wrong, right? And legally, it was even legally as well. But there are a lot of questions stayed with the public, with the media as well. So since this case been involved the current Minister of Justice, who also denied this kind of stuff, I think it's police. It's the expectation from me and also from the public is I hope this case already involved these high officials and also involved the press freedom, which is really a guarantee of our political rights in this democratic country. I think the police should be proactive on this and should provide more information in this regard. But otherwise, it's still really questionable, and we don't have enough information on this issue.
So, when is spying and gathering intelligence or tapping conversation is justified? Because that was illegal, and when is it illegal? When is it legal? There
is a specific laws regulates this kind of procedure from the police and from the prosecutors as well. And as I mentioned, there are specific procedures. If the procedures been followed, it's regarded as legal, of course. And if it's especially in this specific wiretapping case, it seems that this process was not followed.
Right.
And that I'm not sure if there was criminal case even for the journalist. It was just on behalf of some officials, these two police officers were gathering information without the criminal case backgrounds, I guess. So
what I meant to ask was that what kind of criminal offense would it take to justify this action? Because something related directly to the security of the nation would justify this totally.
No, there is no specific that this kind of crimes would requires wiretapping or not. It's all crimes can have this kind of procedure now.
I see. Yeah. I see. So, what about the journalists? Did they make any, complaints again after that?
I'm not sure about now, but before when the issue was first raised, I've seen some news that the Journalist Association were actually following this issue to the Ministry of Justice and also with the Police General Authority, and they declined. For example, Ministry of Justice to say that it's not our power to, give some information to the specific cases, and the as far as I remember, the General Police Authority say that it's a secret.
I see.
Basically,
so, who has the right to investigate this stuff then? Like, because when the police, general police or the intelligence office is related to any criminal offense, who has the right to investigate this stuff? Maybe some
if the case is involving police officers doing something illegally, it's up to the intelligence office to investigate it.
But in this case, the intelligence office itself was really...
No. I mean, the intelligence office was actually the office, not the officers.
Right.
The office was the first to provide this information to the public, that police officers, which has a power to this kind of wiretapping, did this kind of stuff.
I see.
So it started from the intelligence office.
I see. So spying on journalists is certainly offense to the right of the people, to receiving information, right?
Yes, of course. Yeah, the press freedom, it's a guarantee, the institutional guarantee for the people's right to obtain information, right to disseminate information. It's an institutional right, not just a personal right. So it's a functioning democracy always would require this kind of free and diverse and media that is not that does not have any fear from the government.
I see.
Yeah.
So let's get into our third topic.
Okay.
Court session of the 60 billion conspiracy case was held this week. However, the offenders, Sandui and Ganbaatar, was found guilty of rigging election process instead of conspiring to get a high-level position illegally. They were given a 4-year sentence each. So our first question about this one is, did you see the court session?
Not the court session, it's about the news about it, of course.
Okay,
yeah.
so
Yeah.
how do you evaluate this process as a lawyer?
Right, this case is really sad, sensitive and highly politicized. And as a personally who usually who works for democratic promotion, it's really inappropriate for someone to talk, someone to plan to sell the offices for the public for the party funding, right? But still, in functioning democracy, the rule of law has to be upheld, and the due process of any charges should be followed. So as far as I understood from the media and also Twitter discussions on this issue, the court decision was really unexpected. Because this, as I understood, the prosecutors' indictment and also the advocate's defense was based on a specific charge, that is the conspiring to get a high level of this position, right? But without mentioning this rigging election charges. But after the discussion in the hearing, in the judicial discussion, it seems that the judge just come up with this totally new charge, even though they're saying it's a kind of mitigating lesser crime that
right.
they are doing because it's in a favorable condition for the defendants. But still, it seems it's really probably new practice. I'm not sure, because it's within the even legal community, it was really unexpected result.
So they were sentenced a totally different offense. Could you explain the process of this? Like, some people say that the end goal was to charge them no matter what, and they would have gotten a much more serious sentence if they were charged for the 60 billion conspiracy. So could you explain the process? What exactly happened, and why were they charged for this totally different offense?
That's the thing we don't know. We were expecting in a normal procedure, the prosecutor's office would provide their indictment on the charging. They would charge on a specific crime, and the defense would provide their defense specific on this specific charge, specific criminal charge. But when judges came up with a totally different new crime, this actually means that there was no defense, and there were no indictment from the prosecutor's side as well. Right. Which means that the issue would actually relate to the right to defend himself, because people, in order to exercise on the person's right to defend, they should have all the information regarding the charges they are being indicted from the prosecutor's office. But in this case, if the judges would come up with totally new charges, which means there was no defense.
Right.
Yeah.
So is there a law that every piece of information must be provided before?
Yes, there is a law, of course.
So they didn't follow that.
Basically, I think law is really cut clear, and and of course, I hope that the defense side and also prosecutor side would go up to the appellate court and would follow this decision, because it's only first instance court decision, and who knows what. And I would at the next level court would come up with the more proper decisions and more proper decisions that would convince or that would restore our trust in the judiciary.
Right. So, is there any co-conspirators with them? Like there should be any other people that took part in this conspiracy?
As I understood, the criminal charges were separated on the specific people. So it was a decision for specifically these two people. So which means the procedures are separate happening now.
I see. So what of the co-conspirators? What of the co-conspirators?
Sorry?
What of the people who were involved in this? Would they just go off?
No, I don't think so. It's just a separate procedures are going.
So they will be judged in a different case.
I'm not sure, different case or different crime. I'm not sure, because now it becomes a bit unexpected now. Yeah.
Right. So. Did the court make a decision against the rule of law? Is this one?
Rule of law, this is
could you explain and give a little bit of background information about the rule of law to our audience?
The rule of law is the founding principle for democratic constitutional country, which basically means everything has to go according to the law, and also regardless of who is being charged. Which means that since this court decision was such an unexpected in terms of the classification of crime, and also in terms of a statute of limitation, was really, really interesting. So currently I'm of opinion to say that rule of law was not really followed in this case, but still there are higher courts, so still we're hoping for the proper procedure. Yeah.
Right, so what kind of offense does it take, and what kind of charges does the criminal offenders of the people who try to sell offices get? As a lawyer yourself, could you please give us some information, because most of the people who are related to this big kind of conspiracies go off easily.
I think it was within the prosecutor's indictment that they are conspiring to get a high level position illegally, right? But it seems that even though following this charge, the statute of limitation, which means in a human language, which means that certain crimes are not charged after a certain period of time, right? I think this was also after the timing was also really neared to the statute of limitation. So I'm not sure about how they should be charged, but whichever the charges they charge, it should follow the criminal code, criminal procedural code, and this procedures that is already clear cut.
Well, as for the 4-year sentence, is this the full amount? Because rigging an election is, at least for me, it's a serious offense. So, giving how much, criminal.
This is an issue of policy of crime, and it relates to what kind of crime. It relates to the state policy on what kind of crime the state would take seriously and what kind of crime is, taken less seriously. So, the criminal code reform been happening for a long time in Mongolia.
Right.
It just since the 2012, and it seems that 4 years is probably for rigging election. They said the state and the parliament set the 4-year term, right, of the imprisonment. And I don't think the 4 years is a small amount of imprisonment, because it seems that the imprisonment is not a I would say, it's not an easy crime. It's the harshest one, harshest punishment for the criminals, and we don't have to have this harsh on many crimes, I think.
Right. So, could you tell us more about the judicial system of Mongolia? Because Mr. Jargal said that because of the judicial system, the people, the offenders who are related to the corruption cases are going off easily, and that with the constitutional amendments, this can be only fixed. So, could you give us some background information on that? Maybe what does it take to solve the case of corruption case?
Okay, so you mentioned also constitutional amendment, and the general perspective is that not just the corruption cases, but all the cases are being decided on the court, right? And the basic principle of the court is independence, that the judges, which is capable of deciding this kind of really harsh cases, should be independent from any high officials, independent from their even personal biases and personal prejudices as well. So we have this General Judicial Council mentioned in the Constitution, which should take care of this independence in terms of material, in terms of other conditions they have to provide it to the judiciary, so that judges can work freely by themselves. So currently, the general criticism related to this office is that it's also only have 5 members, which is all appointed by the President of Mongolia. And also there is a Judicial Ethics Commission attached to the General Judicial Council as well. It's also all the members were appointed by the President's office, and the corruption office is also, the anti-corruption office's head chairmen are also nominated by the President's office, which basically give some people the suspicion that why it's all concentrated on the President's office, all this judicial system. And also highest prosecutors also appointed by the President's office as well. So this kind of too much consideration of the power, judicial power, appointment power and removal power to the President's office makes it really questionable. So current constitutional amendments try to decrease this high power. For example, the amendments have this clause to draft to increase the number of the Judicial General Council members from 5 to 10, which would, and also the composition and how they would appoint it is not just through the President of the Mongolia. It will be sent from different offices, so that they would check each other, right? And also constitutional amendment also have a specific clause that would limit the President's power, which was given to the President by the other law, not the Constitution, but by the other law. In the Constitution, there is a specific set of powers for the President that President has, for example, powers to initiate law, like there's a list of powers for the President. But the recent trend in the last 10 years, regardless of who was the president, all the presidents tried to increase their power through passing new laws which would give them more powers, especially in the judiciary. Okay. So that's the main rationale for the constitutional amendment. We hope that if this judiciary part would pass by the parliament, it would have a good impact on the judiciary.
Okay, so thank you for that. Well, unfortunately, that is all the time we had for today. Thank you for staying with us. We will see you next week with more topics. Have a nice evening. Goodbye.